Thank you, everybody, for being here. Today's webinar is going to be on responsible parties for a fair housing violation and try to make a determination as who can be liable when a fair housing violation has occurred. So we're going to try and answer a couple questions. First, does the Fair Housing Act and other laws identify who may be liable for a fair housing violation? And if so, what do those laws say about it? And also, can an owner, management company, or other housing provider, such as a condominium board or co-op board, be directly liable for discriminatory actions of their employees or agents? Can an owner, management company, or other housing provider be held liable for discriminatory conduct of one tenant against another, or neighbor on neighbor type situation? And last thing, what is vicarious liability and who can be vicariously liable for a fair housing violation? So the ground rules, as previous webinars, is the webinar is being recorded, and put the questions in the Q&A, not the chat. However, if you put it over into the chat, I'll be able to answer it as well. And the webinar here is provided to provide general information. If you have specific questions on a given case or complaint, reach out to our office directly, 313-579-FAIR or Fair Housing on YouTube. Thank you for Mishta for sponsoring this webinar. Really appreciate it, for sponsoring this one and other ones. So kind of here's the outline. We're going to, it's a challenge determining who may be liable when there's a fair housing violation. We're going to look at that and what the laws say about that. We're going to consider standards for direct liability and then standards for vicarious liability. So those are the main things. What we're not going to cover, though, is liability of governmental entities and officials and insurance carriers. Those will be addressed probably in a separate webinar. I mean, the general rule is that you can't sue the federal government for monetary relief, nor can you sue a state government dealing with their barred claims for monetary damages against state government are barred by the 11th Amendment. However, local governments and officials can be liable or can, fair housing claims can be brought against them. Liability insurance is certainly something that should be considered, but these are just too far beyond the scope, too time consuming to cover it today, although these are really important questions. But contact our office if you have questions about these kind of questions occur. So what's the challenge for determining who may be liable for a fair housing case? Well, first, real quick, the main fair housing laws. You can see the Fair Housing Act was passed in 1968, Title VIII. Title VII was dealing with employment. That was passed in 1964. Took a few more years till the Fair Housing Act got passed. Fair Housing Act got passed in 1968. It got amended in 1988 to add familial status and disability. It protects all persons. And you can see the 7 protected class categories there on the right. 2 laws that go way back. Civil Rights Acts of 1866 and 70. You can see Section 1981 and 1982. Section 1981 prohibits discrimination in contract rights, a lease, a mortgage, any kind of a contract, employment contract. It's protected from discrimination under Section 1981. Protected class categories include race, color, ancestry, and alien status. Same thing with 1982. 1982 deals with property rights, real and personal property right. Equal Credit Opportunity Act lists, you can see it here, listed here, there are 7 protected class categories, includes marital status and age, which makes it a little bit different than the above laws. And then Section 504, federal law deals with, protects disability. But here's the question though. Who may be liable under these laws? And the Fair Housing Act doesn't specify who may be responsible, who may be liable, who could be sued for a fair housing violation. Neither does Section 1981. Neither does 1982. Equal Credit Opportunity Act gives liability to a creditor, prohibits a creditor from discriminating. So it does identify who can be a defendant or respondent. That's as far as it goes. Section 504 just lists responsible parties as those involved in failure to provide accommodations as necessary or to include, make programs accessible if they're programs involving federal financial assistance or conducted by a federal agency. But that's as far as it goes. So the Fair Housing Act, again, doesn't specify it. There are 2 exceptions, Section 805 or 42 U.S.C. Section 3605. It gives rise to liability against lenders and appraisers, those that are involved in a residential real estate transaction. That is listed, as well as Section 808 or 42 United States Code 3608 has requirement for federal agencies to affirmatively further fair housing. But for the most of the situations, right, apart from those two exceptions, basically, this is noted by Meyer versus Holley, the Supreme Court in 2003. It said the Fair Housing Act itself focuses on prohibited acts, right? It tells people what they can't do or what's discrimination. It says nothing about vicarious liability. It just leaves it open. In NAACP versus American Family Mutual Insurance Company, 1993 case out of the Seventh Circuit, 1992 case out of the Seventh Circuit, cert was denied in 1993. It says by writing its statute in the passive voice, banning an outcome while not saying who the actor is or how such actors bring about the forbidden consequence, Congress created ambiguity. And it did in terms of who would be liable. I don't think it's an accident. I think Congress did it. Congress did not want to be overly specific so that the Fair Housing Act could be flexible to address situations. Certainly, Congress is not going to pretend to know all the various situations that could give rise to a fair housing violation. So they don't specifically specify. That's often what's done, right? Legislative bodies are always concerned. They want to make sure they have coverage and they don't limit it by specifying in language specifically who would be liable. So how does the gap get filled? Two ways. There's court decisions and there's HUD. This is HUD's Fair Housing Act regulation dealing with liability for discriminatory housing practices. We're going to say a lot about this regulation. 24 United Code of Federal Regulations, section 100.7, liability for discriminatory housing practices. So part A is direct liability, or subsection A, direct liability. Subsection B is vicarious liability. Within direct liability, there's three parts. A person is directly liable for their own conduct, right? That is discriminatory. Another way a person can be direct liability, failing to take prompt action to correct an undiscriminatory housing practice by an employer or agent where they knew or should have known of discriminatory conduct. And the third part is failing to take prompt action to correct an undiscriminatory housing practice where they knew or should have known of the discriminatory conduct and had the power to correct it. And that's the main one. Vicarious liability. Person is vicariously liable for discriminatory housing practice by the person's agent or employee, regardless of whether they knew or should have known. I got a graphic on the next slide. It kind of gives an idea of what this looks like. You can see there are two types: direct liability, person liable for own conduct, and then failure to take prompt action to correct their undiscriminatory housing conduct or housing practice by their employer or agent where they knew or should have known. I kind of have that kind of highlighted with color, and it overlaps with vicarious liability. It says person liable for discrimination by an agent or employee, regardless of whether they knew or should have known, consistent with agency law. Those two definitely overlap. And then for direct liability, part 3 deals with discrimination by a third party, such as neighbor on neighbor or tenant on tenant. And the question is, in what circumstances may a housing provider be liable? So that's kind of the breakdown from the HUD regulation. It's a good summary. HUD wasn't trying in this regulation to make new law. It was just summarizing the case law that had existed at the time of the regulation. So first off, what is direct liability? Again, as noted above, a direct liability, person is liable for their own conduct that results in discriminatory housing practice. And I got a green light here. Generally, it's not an issue, right? Direct liability readily attaches a person who engages in the fair housing violation, whether they're an owner, third party, neighbor, or tenant. And really, the only question that arises here in terms of direct liability for a person's own act, occasionally an agent or employee will say, well, I just followed order. Right? The employee says, I did what the management company told me to do, or I did what the employer told me to do, or I did what the owner told me to do. It's not a defense, right? Under principles of agency law, an agent who doesn't act, otherwise a tort. Fair housing violation, discrimination is a tort. Supreme Court has held that it's a tort type claim, injury type claim. They're not relieved from liability by the fact that the agent, acted at the command of the principal or on account of the principal, right? So an agent who assists the principal in committing a violation of the Fair Housing Act is himself liable as a joint tortfeasor. So period. Whether or not they're acting under direction of the corporate owners, they can be liable for violating the Fair Housing Act. So there's no defense. Whoever commits the act at whatever level they have within the organization, they can be personally directly liable for the discrimination. That tends to not be a concern. There can also be direct liability for discriminatory conduct of an employee or agent. And this is under subsection A sub I, A1 sub I. Person is directly liable failing to take prompt action to correct and end a discriminatory housing practice by that person's employee or agent where the person knew or should have known of the discriminatory conduct. Again, this too is generally not an issue. Direct liability will attach to an owner, property management company, or other housing provider, such as condo board, co-op board, public housing authority, whose manager or employee engaged in the actions that gave rise to the fair housing violation. And I've got some cases listed here. Chicago versus Matchmaker Real Estate Sales Center. The corporation was liable for the acts of its agents. Shareholder was directly, not vicariously liable. U.S. versus Ballesteri case. The owner was liable for the agent's racially discriminatory renting practice, of which he knew and failed to stop. Walker versus Krigler, right? Owner of the rental property is liable for discriminatory acts of the agent, meaning the property manager. Heights Community Congress, a realty firm, knew about the fair housing violations by its agents and failed to take corrective action, so therefore they were directly liable for the discriminatory actions of their employee or agent, again, where they knew or should have known of the discriminatory conduct. And you can see, right, U.S. versus they denied a motion to dismiss. The complaint plausibly alleged that the property owner was directly liable for alleged sexual harassment of tenants by its property manager and so forth. A real interesting case is Richards versus Bono, a wife co-owner who knew of the husband's sexual harassment yet failed to stop, was liable for that violation. Now, the question is, if someone is an employee or agent, how do you determine if they're an agent, what the standard for? The law is clear when it comes to federal civil rights statutes. That agency relationship is determined or based on federal law, not state law. The reason is various state laws will vary around the country in terms of what they require for an agency relationship. There's a need for certainty, consistency in federal law, so it is determined under federal law. There's that's from the Harris case. Marvey Rife says it this way: we believe prior decisions in other areas of civil rights direct us to use federal, not state law. And the Burlington Industry case out of the Supreme Court under Title VII, court said Congress directed federal courts to interpret Title VII based on agency principles. Given such an explicit instruction, we conclude a uniform and predictable standard must be established as a matter of federal law. So you have to look at the case law in terms of it. But basically, if someone is acting as an agent or employee of a principal, right, the principal is going to be liable for the action that occurs for the most part. Very difficult to overcome that standard. As long as they're acting, right, doing something in the course of what they would do as an employee or agent, as a resident manager, showing properties, processing applications, accepting payments, different things like that. In terms of HUD in the beginning part of their regulations, 24 CFR 100.20, has a list of definitions. It defines broker or agent to include any person authorized to perform an action on behalf of another person regarding any matter related to the sale or rental of dwellings, including offers, solicitations, or contracts, and the administration of matters regarding such offers, solicitations, or contracts, or any residential real estate related transactions. Another question that can come up dealing with employees or agents is sometimes it's argued, well, it's an independent contractor, so why should that be attributed to the principal, the employer, the owner, the management company? Federal law is pretty clear, right? Contractual language that an agent functioned as an independent contractor does not preclude holding a principal liable for the actions of the independent contractor as an agent of the principal. So that argument has not prevailed very much, if at all. So independent contractor is not a good defense to it. But here's where I got yellow. Yellow means very, very caution on this one. An owner, management company, property owner, housing provider, co-op, condominium board. When there's discriminatory conduct by a third party, such as tenant-on-tenant harassment or neighbor-on-neighbor harassment, the standard is this. This, according to the HUD regulation, a person is directly liable failing to take prompt action to correct and end discriminatory housing practice by a third party where the person knew or should have known of discriminatory conduct and have the power to correct it, the power to take prompt action to correct an discriminatory housing practice by a third party depends on the extent of the person's control of or any other legal responsibility the person may have with respect to the conduct of the third party. In other words, does the owner, management company, co-op board have authority to rein in, terminate the lease or occupancy of a tenant or occupant or resident or co-op owner engaged in discriminatory practices? Most often that answer is yes, one would think. Well, HUD has a kind of a preamble to its regulation dealing with quid pro quo and hostile environment, harassment, and liability for discriminatory housing practices under the Fair Housing Act. And this is that section 100.7. HUD promulgates a proposed rule and a final rule. Here is the final rule. There will be a discussion about why the regulation got adopted, plenty of case citations and guidance as to how HUD intends for the regulation to be used, right, in individual cases. So let me go back for a second. At the bottom, at the top paragraph, it says the power to take prompt action to correct an discriminatory housing practice depends on the extent of the person's control or other legal responsibility they may have with respect to the conduct of a third party. So where does that duty to correct come from? It could be in a contract or lease agreement. There are rules associated with the rental property or co-op or condo. There could be an association's covenants, conditions, and restrictions. There can be requirements under federal, state, or local law. Depends on the control, other legal responsibility the person may have. And you can see it on the going kind of a circular motion. A lease typically obligates the housing provider to exercise reasonable care to protect the safety and curtail unlawful conduct by tenants or in areas under the housing provider's control. And here's an interesting one. I'll read it. Thus, when confronted with discriminatory harassment of one of its housing choice voucher holders or other tenants, the housing agency should explore what corrective actions are within its power and are appropriate to take. So HUD is just listing, it's not all inclusive, but they're listing kinds of rights or authority or responsibilities that housing providers have to address discriminatory conduct by third parties. There's some cases on this, two key ones. We're going to talk quite a bit about those, the Francis versus Kings Park Manor and Wetzel versus Glen Andrews Living Center. In Francis, the Seventh Circuit en banc, I want to say en banc is where all the active judges, not senior judges, but the active judges on the Court of Appeals here for the Second Circuit will vote to hear the case. Has to be a majority to vote to hear it. In the Second Circuit, they did. I think the decision was 7-5 against finding liability on the claim of Francis against Park Manor. They basically said that the allegations were not sufficient, that the landlord failed to respond to reports of race-based harassment by a fellow tenant, were insufficient to establish the landlord was motivated by discriminatory intent. Wetzel versus Glen Andrews by the Seventh Circuit, 3-judge panel. There was a tenant harassment case. They did find potential liability, and there were actions taken by the landlord against the tenant after the tenant complained of the harassment. Not only did they not take action, they took kind of adverse actions or treatment against the tenant themselves. It's kind of amazing. The Newdecker case is another one. Owner may be liable for acts of tenants and management's children after failing to respond to complaints of harassment. So those are some of the cases. A couple more are listed here, right? And Fanbola, right? The landlord knew or should have known the harassment and took no effectual action to correct the situation. In Wilson, you can see there's liability in a condo association, and Reeves is another condo association case where they knew or should have known of the harassment but failed to take action. And Bradley case, owners and management failed to address one tenant's racial harassment of a neighboring tenant. And that was a claim under sections 1981, 1982, kind of overlapping coverage under the Fair Housing Act and sections 1981, 1982. So here's the case studies, right? Wetzel case, Glen Andrews, Living County. And after we go through, Wetzel and the Second Circuit case in King, we're going to kind of summarize those and see what that standard is. But Wetzel held that the Fair Housing Act gives rise to liability when a landlord intentionally discriminates a tenant based on a protected characteristic. right? That's straight up discrimination by a landlord intentionally against a tenant. But it also creates liability against a landlord that is actual notice of a tenant-on-tenant harassment based on protected class status, yet chooses not to take any reasonable steps to stop that harassment. So in this case, right, Wetzel arrived at St. Andrew. She spoke openly to other staff about her sexual orientation. She was met with intolerance. And this shows some of the accounts that were in the complaint. This case did not yet go to trial. It's based on the allegations of the complaint. And beginning after a few months after she moved and continuing at least about a 15-month period, they repeatedly, you can see, I'm not going to go through and give those names, but they deliberately called her all kinds of names based on her sexual orientation. And you can see there were threats made to her. There was physical abuse. She had a motorized scooter. Somebody rammed his walker into her scooter to knock her off a ramp. Another individual bashed her wheelchair into a dining room table, flipping the table on top of her. Another time she was struck in the back of the head while in the mail room. You can see these attacks that occurred were all based on her protected class category. So under the Fair Housing Act, that would be called, it would fall under the category of sex discrimination. And she reported it to St. Andrew's staff. If they just listened and done nothing, that would have been a limited case. But it turns out they took affirmative steps actually to retaliate against her for her complaints. They put her in a less desirable dining room location. They barred her from the lobby except to get coffee. They stopped her cleaning services. They falsely accused her of smoking in her room. While she was sleeping one time, somebody slapped her in the face. And you can see she didn't get a customary rent-to notice. All of these things that she had to change her routine. She ate meals in her room, right? She stopped visiting the third floor. She avoided the laundry room, except for hours when she would be alone. She stayed away from common spaces. So the court found what? That was sufficient, right, to show liability on behalf of Glen St. Andrews Living Community. The case going the other way is Francis versus King Park Manor. Banc. So the majority of the Second Circuit held, first, a landlord cannot be presumed to have the degree of control over tenants necessary to impose liability under the Fair Housing Act for tenant-on-tenant harassment. And second, Francis failed to state a claim that the defendants intentionally discriminate against him on the basis of race. So what happened is Francis, he's Black. He rented an apartment complex in Kings Park Manor. And on September 12th, on 8 occasions from September 12th, beginning in February and September of 2012, the neighbor and fellow tenant verbally attacked and otherwise attempted to intimidate Francis, including racial insults and at least one death threat. He reported Enders to the Suffolk County Police, who then informed the housing provider of the events. And on May 1st, he renewed his lease without comment. In total, he wrote 3 certified letters in which he counted the neighbor Enders's behavior, the police involvement, and his arrest for aggravated harassment, right? And there wasn't any action taken. When his lease expired, 5 months, the neighbor, he was arrested. He vacated his apartment. He pleaded guilty to a charge of harassment. The panel decision, which got withdrawn when the case got heard in Banc, goes into more details, more salacious details of what the allegation and the complaint. Court and Banc majority kind of softens what those allegations are. So here's what happened. The court first said, they described the earlier case, the Wetzel case, as a deliberate indifference theory of liability is how they phrased it. It says, when is here, a plaintiff brings a claim under Fair Housing Act does not rest on direct evidence of landlord discrimination, right? There wasn't any allegation by Francis that they directly, overtly said, we're discriminating against you because of your race like that. So it's indirect circumstantial evidence. To establish a circumstantial case of discrimination, he has to allege he's a member of protected class, he suffered an adverse action, and has at least minimal support for the proposition that the housing provider was motivated by discriminatory intent. And the Second Circuit said, well, They found the allegations insufficient. The court said the complaint lacked even minimal support for the proposition that the defendants were motivated by discriminatory intent. So they said that was not sufficient. Basically, at the bottom, it says he does not allege that the defendants regularly intervene in disputes among other tenants, much less in the practice of addressing tenant-on-tenant harassment, where the matter did not involve a Black victim and a white harasser. And why the court reached that conclusion, they felt that they weren't convinced that the landlords have control over tenants, right? They're assuming, not necessarily agreeing with, deliberate indifference may be used to establish liability under the Fair Housing Act. They said that Francis, even if it is, Francis failed to state a claim. He provided no factual basis to infer that the defendants had substantial control over the neighbor, Endress, and that the context in which the known harassment occurred. And the court basically said you're not going to see that in an arm's length relationship between landlords and tenant, unlike custodial environments of schools and prisons. And I would say too, analogize to employment under Title VII. Under Title VII, employers are responsible for employee-employee harassment under Title VII. So therefore, Francis argued landlords should be liable in the same way because the Fair Housing Act is similarly worded. The court disagreed, said the employer-employee relationship is different than a landlord-tenant relationship in important ways. Employees are considered agents of the employer. In a landlord-tenant situation, the tenants are not agents of the landlord. Also, landlords' control over tenants and their premises is much less than a landlord's control over employees and their workspaces. So they were not inclined to presume that employers' manner and degree of control over agent employees is equivalent to or translate into a landlord-tenant situation. Pretty strong rule going the other way. And the court in Francis then reviewed the Wetzel decision, Seventh Circuit decision, and said it's true that the Seventh Circuit and Wetzel recognize a deliberate indifference theory of liability, right? And the court said in Francis is different than the situation in Wetzel because in Wetzel, there's plausible facts or plausible allegations that defendant landlord had unusual supervisory control over both the premises and the harassing tenants. Moreover, in Wetzel, the defendant housing provider was alleged to have affirmatively acted against the plaintiff. In the absence of any factual allegations suggesting the defendants had similarly unusual degree of control over the premises and tenants, or actively facilitated or compounded the harm to Francis, the Seventh Circuit's decision in Wetzel doesn't require a different outcome. So where are we at then, right? And here's really the bottom line question. Does a claim based on failure to take prompt action to correct an discriminatory housing practice by a third party require proof that of the housing provider's intent to discriminate? HUD says no. HUD's preamble or explanation of its regulation said bluntly, HUD does not agree that a housing provider's failure to act to correct third-party harassment must be motivated by a discriminatory intent or animus before the provider can be held liable for a fair housing violation. HUD also, there's more of a discussion than I'm listed here, but HUD disagreed with the decision in Lawrence out of Florida, 2004, in which a court dismissed a fair housing claim against the housing provider because the plaintiffs failed to establish that the housing provider's ineffective response to harassment was due to racial animus. So that's HUD's position. In Francis, they said it does require proof of intent to discriminate. I'll quote here, "There's thus no question that a landlord may be liable under the Fair Housing Act for intentionally discriminating against a tenant based on race." True. But after more than 5 decades of experience applying this important statute, our court, the panel of the court adopted a rule that would make landlords responsible under the Fair Housing Act, not only for their own discriminatory acts, but also for failing to respond to tenant-on-tenant discriminatory harassment. Although framed in terms of intentional discrimination, the panel majority's decision effectively established the landlord's positive duty under the Fair Housing Act to police the conduct of tenants and their relations with each other. So the answer is this: Francis says no. They do require proof of discriminatory intent. Francis did not say well, the HUD's regulation is invalid. Francis didn't go that far, but implicitly, it really is a disagreement with it. These cannot be reconciled. But again, this is in the Second Circuit, not clear whether that's something that will spread to other circuits as well, or if it's just in the Second Circuit. Kind of to summarize it two ways, these are the two views. The Wetzel case and HUD will apply the Title VII employment standard, right? Under employment standard, Title VII employer may be liable when its own negligence is a cause of prohibited harassment. Supreme Court's interpretation of analogous anti-discrimination statutes satisfied the court that Wetzel's claim against St. Andrews is covered under the Fair Housing Act. HUD does the same thing, right? HUD will analogize to Title VII law, and you can see the HUD regulation here. Francis, however, rejects the Title VII employment standard. And it says the deliberate indifference theory applies almost exclusively to custodial environments such as public schools and prisons. They're not even willing to analogize to the employment standards. I'll put this link. We are hard pressed to presume that employers' manner and degree of control over its agent employees is equivalent to that of a landlord over its tenants. And so what standard is used in Francis, right? The standard for establishing discriminatory intent, right? They analyze it under the familiar McDonnell-Douglas burden shifting framework first developed in Title VII cases. So interesting that Francis uses the Title VII standards for establishing discriminatory intent as to the landlord, owner, management company, but then does not look to Title VII when it comes to managing discrimination by third parties or by employees or by their, taking it to the tenant-on-tenant, neighbor-on-neighbor situation. And so basically it requires either direct or indirect circumstantial proof of discrimination. And the third element in the bottom right is key, must establish that the housing provider has at least minimal support for the proposition that the housing provider was motivated by discriminatory intent. So this is why when it comes to this third one on tenant harassment or discrimination, I put a yellow flag, right? Again, safe approach, try to show or make an allegation that the landlord, owner, management company, co-op, condo board had an intent to discriminate. Otherwise, if it's just a generalized duty, you may run into courts citing the Seventh Circuit standard. That's the concern, right? You end up with the Second Circuit standard in Francis. One other thing that comes up there, subsection 2 in the regulation, 24 CFR 100.7, subsection A, subsection 2, says for purposes of determining liability, prompt action to correct a discriminatory housing practice may not include any action that penalizes or harms the aggrieved person, such as eviction of the aggrieved person. And Miller versus, make sure I'm recording. Yeah, Miller versus Town Oaks East Apartments. The landlord is liable for violating the Act, the Fair Housing Act, by evicting both the harasser and the victim of harassment instead of only the harasser. So that will make clear that the way to correct an discriminatory housing practice should not penalize the person who's aggrieved or been injured by the discriminatory housing practice. Last part is vicarious liability. Person is vicariously liable for discriminatory housing practice by the person's agent or employee, regardless of whether the person knew or should have known of discriminatory conduct consistent with agency law. Property management company or housing provider, condominium board, co-op board, PHA, will typically be found liable for fair housing violations where its manager or employee engaged in the actions that gave rise to the fair housing violation. The key decision here is the Supreme Court's decision in Meyer versus Holley. The Supreme Court said it's well established that the Fair Housing Act provides for vicarious liability. Right? Traditional vicarious liability rules ordinarily make principals or employers vicariously liable for the acts of their agents or employees in the scope of their authority or employment. So what someone's employees or agents do will be imputed to the principal, to the owner, to the management company, to the board. They're going to be responsible, right? As long as they have some degree of control over the agent and manage or manifest some evidence, right, that they permit one person to act on their behalf and consent to another person to act on their behalf. And by the way, too, a corporate employee only acts on behalf of the corporation, not the owner or officer. We'll talk about that in a second. And here's the key one: liability of corporate owners and officers. The liability goes upward from agents and employees to principal or employer. It doesn't go downward from the corporate entity or employers to the individual owners and officers. In the Meyer versus Holley decision, the actions or discrimination of the corporation was imputed down to its owners and officers. The Supreme Court reversed the Ninth Circuit on that. Right, corporate owners and officers are not liable for the unlawful acts of the corporation employees. The corporation employees' actions get attributed or imputed to the corporation. They don't attach to all the corporate owners and officers. So it doesn't work that way. So no corporate officers, right, and owners, like shareholders, whatever, should be named as responsible parties or as defendants unless they were actively involved in the discrimination. Instead, just the corporate entity, the company, should be named as the respondent. Be careful about doing that. Again, you can name the employees or agents involved in the discrimination and then name the corporate entity, the company itself. That's it. Unless, again, there's evidence to show that the individual persons were also involved in discrimination. HUD regulation, we see it here based on the Supreme Court decision, consistent with the Supreme Court decision, there was vicariously liable. And again, the liability applies whether they knew or should have known of the conduct that resulted in discriminatory housing practice. It's purely based on agency law or federal agency law. And you can see lower federal court decisions. I listed just a couple of them. Vicarious liability attached to a property owner where the property manager's position essentially gave him unfettered access to communicate with and personally visit the plaintiff. He uses power as property manager to perpetrate his unlawful conduct by refusing repairs, raising the rent, attempting to evict the plaintiff as a consequence of her refusal to provide sexual favors. By the way, you can say, well, doesn't seem like they're acting as an agent, sexually harassing a tenant. No, but the connection between them being an agent, employer agent, is based on the fact that by virtue of the property manager's position, he had access to communicate and directly contact tenants. So that was sufficient to provide vicarious liability. Glover versus Jones, they can be liable even if they act outside the scope of employment, if the employee was aided in accomplishing the tort by the existence of the agency relation. In other words, did the fact of someone being an employee of an entity give them access to or provide the setting in which they could then engage in the discriminatory practice? Richards versus Bono, the wife, co-owner of property, she's vicariously liable for the husband's harassment, where the husband acted as her agent and used his position as owner, property manager, and maintenance supervisor to subject the plaintiff to sexual harassment, where he used the key to enter the plaintiff's apartment and then threatened the plaintiff with eviction. So one little qualifier on this, we've got a webinar on damages that have more detail on this, but agency principles restrict liability for punitive damages. In fact, everything we talked about previously can make a property owner, management company, condo board, and so forth liable, but those are only for compensatory damages. For punitive damages, there's a restriction here. In punitive damages, the employer or principal must have either participated in discriminatory acts or ratified them. And the Supreme Court in Colstead, and this is applied in fair housing cases, give the standard, the 4 elements to see whether principal has ratified the act, right? The principal authorized the doing and manner of the act. The agent was unfit. The principal was reckless in employing him. The agent was employed in a managerial capacity or acting in the scope of employment. And the principal or managerial agent ratified the act, right? It can be liable for punitives, right, by action or knowledgeable inaction. Once they know about the discrimination that occurred and they don't take corrective steps, they can be held to have ratified it. You can see Darby case was a big verdict. Evidence submitted to the jury regarding the employer's inconsistent statements about whether its employees received any training concerning fair housing, concerning civil rights laws. A jury could reasonably draw inferences that the defendant had failed to act to prevent known or willful disregard or willfully disregarded actions of its employees. In Washington versus Cron, punitive damages available where the defendant was hands-on property owner that monitored vacancies, advertised for tenants, established criteria for selecting tenants, and required the apartment managers to give him their impressions of prospective tenants, and personally chose among prospective tenants based on their applications and the manager's comments. These are some of, seem harsh, but the courts look at it this way. When there's discriminatory conduct occurs, who should bear the responsibility for the violation? Should it fall on the innocent tenant victim, or should it rest with the company? And that's how they cut it that way. But again, has to be a higher showing for punitive damages. So let's summarize where we're at. These are 2 hypothetical fact patterns. Let's say a maintenance employee makes sexual comments or innuendos in front of a tenant while working on repairs. Although the tenant did not experience any threats to her housing, the sexual conduct was still unwelcome. And we'll go through these 3 questions here. And I'm going to just jump to the next slide and kind of answer them. Is there a person liable for their own discriminatory conduct? Yes. If so, who? Who would be liable? The maintenance employee may be found liable because he engaged in what? Sexual harassment. Is there any liability for failure to take prompt action to correct then discriminatory conduct by the employer agent where the principal, right, management company, owner knew or should have known of discriminatory conduct? Not clear here. It doesn't say that the tenant reported the harassment to the employer, the management company, or the owner, so it's not clear. Third part, is there any liability for failure to take prompt action to correct then discriminatory conduct by a third party where they knew or should have known of the conduct? No, there's no third party involved here. It wasn't tenant-on-tenant. It was directly as a maintenance employee making the sexual harassment, right? So is there any vicarious liability? Any person liable for discrimination by agent or employee, regardless of whether they knew or should have known, consistent with agency law? Appears yes, right? The management company or owner may be held liable for the actions of the maintenance worker as its employee under vicarious liability. Let's take a third situation. I'll jump here. A housing provider is informed by one of their tenants that they're being harassed by another tenant because their family is biracial. Instead of addressing the situation or taking action, they refuse to help, allowing the harassment to continue. Is there a person liable for their own discriminatory conduct? Yes. The tenant committing the harassment may be held liable. Prompt action to correct discriminatory conduct by an employee or agent? No, there's no employee or agent was involved in the harassment. Third, is there any liability for failure to take prompt action to correct and discriminatory conduct by a third party where they knew or should have known of discriminatory conduct? The answer would be yes. Under HUD's regulation and the Seventh Circuit decision in Wetzel, yes, there would be liability. Under the Second Circuit's decision in Francis, there must be alleged and proven at least some minimal support for the proposition that the housing provider was motivated by a discriminatory intent. In other words, what? The housing provider kind of didn't take action because they wanted the harassment to occur, or they had some involvement in the racial harassment based on race, against a biracial family. So it's kind of difficult on the third element, stronger under HUD regulations and the Seventh Circuit decision in Wetzel, not so more iffy under Francis. Any vicarious liability? No. because there's no employee or agent involved in the harassment. So that's kind of an overview of how these questions will be answered to determine who's liable for a fair housing violation. So let's answer the questions raised at the beginning. Does Fair Housing Act and other laws identify who may be liable for a fair housing violation? Nope. Fair Housing Act and other federal fair housing laws generally do not identify who may be liable for a fair housing violation. As a result, courts and HUD have articulated standards for determining who may be liable for a fair housing violation. Can an owner, management company, or housing provider be directly liable for discriminatory actions of its employees or agents? Yes. General agreement that an owner, management company, or housing provider can be directly liable for discriminatory actions of its employees or agents. Yes, there is direct liability for that. How about liability for the actions of one tenant or one neighbor against another tenant or another neighbor? Again, some courts impose direct liability on an owner, property management company, or housing provider under deliberate indifference theory of liability for failure to address the actions of third parties, typically neighbors who commit fair housing violations. These are often harassment of another tenant. The duty or power to take prompt action to end discriminatory housing practice of a third party depends on the extent of the person's control or other legal responsibility they have with respect to the conduct of such a third party. The duty can be found in the rules, in the contract or lease, including bylaws. Right, so that's some courts. Other courts, like the Second Circuit, are more restrictive and will not impose liability on an owner, property management company, or housing provider, absent some showing that the owner, property manager, property management company, or housing provider, in failing to take action, was motivated by discriminatory intent. Last, what is vicarious liability? Traditional vicarious liability rules ordinarily make principals or employers vicariously liable for the acts of their agents or employees in the scope of their authority or employment, and vicarious liability has been applied in fair housing cases. Of course, the key decision is Meyer's. So what are the key resources? I really think, it's other areas of law, you have a whole bunch of court decisions and everything else like that. Here we've got three of them just stand right out. Meyer versus Holley by Supreme Court 2003, Francis and Wetzel. Francis in the Second Circuit, the banc decision, and Wetzel. Those are the key court decisions. HUD's rulemaking, 24 CFR 100.7, is a great source, right? That gives the standard that HUD has articulated. HUD announced I have the final rule and the proposed rule. There's a lot of discussions and case sites as to those standards. HUD took the position that, well, they're not creating new rules or new liability standards. They're just going off existing case law. And courts have kind of bought that, may not necessarily rely on what HUD said, and they're just doing what kind of like HUD said, just following what the case law says. But I still find the HUD rulemaking good guidance, and the discussion that they have in the Federal Register for the final rule and the proposed rule give a great deal of background and guidance in identifying responsible or liable parties for housing discrimination. Of course, the key treatise could almost list Professor Schwemm's treatise in every webinar, but he does a good job, as he does on other topics, dealing with defendants who may be liable. That's chapter 12B of his treatise, and that's another good source as well.